Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina, and today's topic is what happens in their smoke-filled room? Cooperation and collaboration among antitrust regulators. Regulators and parties alike recognize and appreciate the potential efficiencies of regulators collaborating with one another on certain antitrust investigations and reviews. But such cooperation is not a one-size-fits-all solution, and has many potential pitfalls as well. In this episode of our Curious Amalgam, we discuss what cooperation looks like today, what it may look like tomorrow, and what practitioners should be thinking about when presenting to and negotiating with multiple regulators. Joining me today is my co-host, Matthew Hall. Hi, Matthew.
Hi, Christina. It's great to be back.
Welcome back. So what are we talking about today?
Well, as you mentioned, we're going to be discussing cooperation between regulators worldwide on antitrust and merger control investigations. I think it's fair to say that this cooperation and collaboration is increasing for a number of reasons. And as you intimated, this impacts cases and case management from both a substantive and a procedural point of view. So we're going to look at the background to this, specifically what's happening in the antitrust and merger control area, and get some practical pointers in the area.
Great. And who do we have as our guest today?
Well, we're very pleased to welcome Meghan Rissmiller. She is a partner in Freshfields Antitrust Competition and Trade Practice based in Washington, D.C. She represents clients in merger and also non-merger investigations before the U.S. DOJ and FTC. She also provides counseling advice on antitrust issues and has litigated many cases in federal court. Hello, Meghan.
Hi, everyone.
Thank you very much for joining us. So we're going to be discussing cooperation and collaboration among antitrust and merger control regulators, but of course there's a big wide world out there. And I think there's a general background to this, particularly with the new Biden administration, in terms of global coordination, hopefully improving generally. Can you look at that background a bit to give us some context to this?
Yeah, sure, Matthew. I think it does make sense to look at competition coordination in the broader context. There's really a general sense today, especially from the U.S. perspective, where the last administration was isolationist, that there is a return to internationalism and a global ability and desire to work collaboratively to address the world's most pressing issues. So the Biden administration has made clear in the first 6 months its intention to participate actively in international institutions, to engage in meaningful diplomacy, and to assume a greater role on the world stage. And I think the U.S. is not alone in seeing the importance of international cooperation and acting on it. So other countries have raised their hands to join in multilateral efforts to address global problems ranging from climate change to dealing with COVID-19 and its aftermath. You look at the G7 summit that happened a couple of weeks ago, and the leaders agreed to provide 1 billion vaccines to developing nations, agreed to end subsidies for foreign coal projects, and aligned on a minimum tax on large multinationals. So you could say this was a success in terms of global cooperation and really a reflection of things to come. And I think for a lot of countries, competition and antitrust issues and the perception of increased consolidation falls into those categories of important global issues that should be addressed as a global community collectively.
That must be right. And as you say, the G7 summit is hopefully a good example of this kicking off in a big way. They did produce a nice communique. I don't think it actually referred directly to antitrust, which perhaps isn't that surprising, but it was certainly a good start. And also, as you say, clearly big tech and the antitrust, if you like, attacks on big tech are one big issue that the regulators are clearly worried about in virtually, if not all, jurisdictions. But let's look at competition and antitrust more generally. Does our thesis apply, and has it been applying even before the Biden administration came in terms of increased collaboration, greater coordination? Do we see signs of that? Is there any evidence of that actually happening?
Yeah, so I'll say I think the increased collaboration that we are seeing and starting to see happen is really reflective of, as you said, a consensus among many regulators that merger control may have been too lax over the last decade or so. And the perception is that has led to increased concentration in a number of sectors. So not just tech, I don't want to pick on tech, but things like healthcare, pharmaceuticals, agriculture, and others. And I think there's been a collective questioning of whether the substantive approach to merger control is sufficient. So in the US, of course, one of the specific debates is over the consumer welfare standard. But there are other debates over things like whether merger control should take into account innovation impacts or public interest concerns like income inequality or racial disparities. Additionally, we see regulators looking at deals that otherwise or sort of traditionally would not have gotten a particularly close look. So vertical mergers, deals involving potential and nascent competitors, so killer acquisitions, and deals that might result in a consolidation of data in one firm. I think as a result, we will expect, or we're seeing, greater scrutiny of deals. And you're exactly right that some of this greater scrutiny started potentially prior to the Biden administration taking office, which I think we'll get into a little bit later. But I want to point to some of the specific signs of international collaboration or announcements or efforts that are underway today. So first, there was an announcement from the UK, Germany, and Australia related to a joint statement on merger control enforcement. And you'll note that of those three jurisdictions who contributed to that statement, two of them are voluntary regimes, the UK and Australia. And so traditionally, those were thought to be the most business friendly. Now, if you take signs from their communication related to this joint statement, then they're saying that they may become some of the most tough regulators out there. So they said there's a common understanding across competition agencies on the need for rigorous and effective merger enforcement. And they continued, competition agencies have an opportunity to reassess their approach so that a degree of uncertainty about future developments in the relevant markets doesn't lead by default to a clearance decision. So again, this is a communication from three major merger control authorities, two of which are voluntary, saying that merger control authorities need to look more closely at transactions. Another example is the multilateral working group to build a new approach to pharmaceutical mergers. That's a bit of a mouthful, but that's an effort that was spearheaded by the Federal Trade Commission here in the United States. And it's between Canada, the EU, the UK, and also the US, of course. And FTC Commissioner Slaughter stated that the intention of this working group is to look at how the regulators have looked at pharmaceutical transactions historically and assess whether or not they're taking the right approach to that type of merger review. And as part of that, as part of the working group, they've announced that they do intend to take an aggressive approach. So nothing really has come out publicly from this group yet, but it's another sign of increased cooperation really to look at how best to substantively analyze competition questions.
And Meghan, a lot of what you're mentioning is cooperation and collaboration around how to think about these new issues. How do we think about the pharmaceutical industry? How do we think about nascent competition? Do we need to change our overall analysis or framework for understanding these cases? But on a case-by-case basis, my experience is that regulators, while they will communicate with one another, are sort of analyzing it for, under their framework, under their precedent, almost out of necessity. So how does that collaboration on sort of the higher level thinking translate to case-by-case cooperation and collaboration?
Yeah, so I think you're really getting to a practical question, or sort of a discussion about the practical implications of doing a deal in a global context, where, as you say, the regulators do have different rules, different timelines, different approaches. And, I almost feel like in this day and age, it goes without saying, when you're doing a global deal, you really can't think of a single jurisdiction in isolation. And there should always be an assumption that the regulators will work together, even in the absence of a waiver specifically that would enable the regulators to share documents, though in most cases, parties will, of course, grant waivers. I think the first implication of that, practically speaking, is that parties really need to have a consistent story across jurisdictions. So you can't tell one regulator something and then tell another regulator something that's inconsistent. So, for instance, you can't argue that a market should be viewed in one way in a given jurisdiction and another way in a different jurisdiction. And that's really not going to be particularly compelling, especially if the products are traded globally. A second implication for parties relates to timing and aligning review periods across jurisdictions, with potentially the aim of achieving a global remedy if one is required. So, as you say, every merger control regime has its different processes. So in the US, for instance, there's no formal pre-notification period required to file an HSR. But in the EU and a number of other jurisdictions, there can be these lengthy pre-notification periods. And so given this difference, it may make sense as a strategic point to try to align timing of the substantive reviews so that they're all occurring concurrently, or as concurrently as possible, in all jurisdictions. That way, that if a remedy is required, it's possible to offer a single remedy that would satisfy regulators. And so you would do this, or you would find this desirable, because you'd want to avoid a situation in which a remedy is accepted in one jurisdiction, but not in another jurisdiction, or an authority in one jurisdiction, after having aligned on a remedy, comes back and asks for more based on the remedy package required in another jurisdiction. So, I think that our listeners probably want to think about real world examples, and real world examples are certainly the most interesting things to talk about often. So, a real world example that's really unfolding before all of our eyes of how global coordination is working among regulators, and also how it's having an impact on parties and on transactions, is the Illumina Grail transaction. And the FTC filed suit both in its own administrative court and federal court to block the transaction. Following the disputed Article 22 referral process, the EC took up an investigation of the transaction. So I won't go into much detail here, but in short, the deal otherwise wouldn't be reportable in the EC, or before the EC. And so this, in addition to the CMA's expansive interpretation of the share of supply test, which I'm sure Matthew has lots to say on that, is an example of merger control regulators expanding their own jurisdiction to capture more deals. But I do digress a bit. So back to the story of where that transaction is. So once the EU took up its investigation, the FTC moved to dismiss its motion for preliminary injunction in the federal court. So while the EC investigation is pending, of course, the deal can't close. And you don't need a preliminary injunction from a federal court to stop parties from closing if there are still conditions to close outstanding, like EC clearance. So this procedural situation in which those parties find themselves is quite challenging. If the US were investigating this deal independently, the parties may have had a shot at a quick victory if they were able to defeat the preliminary injunction in federal court. And while with the EC investigation pending, and likely an investigation before the CMA, this quick path to victory, which is a real possibility given the case law related to merger control in the United States, was blocked. So there you have a real example of the impact of global coordination on a deal that's unfolding literally before our eyes.
Now that is an amazing...
Sorry, I was just going to say, I think arguably that transaction is evidence of sort of poor coordination, in that, the EC jurisdiction was claimed several months into the investigation, so sort of springing jurisdiction as opposed to coordination from day one. And I think the parties themselves were quite upset about that fact. If they'd continued on the EC process on day one, maybe they'd be in a similar situation where they'd be able to just litigate and close the transaction. But maybe Matthew has more to say on that, I'm sure.
I was just going to say, I think that it is an extraordinary and worrying in many ways transaction. I just wanted to jump back to Meghan, your comments a bit earlier in terms of substance and how the regulators are thinking about things. Do you think that you talked about the consumer welfare standard? Of course, that also applies to issues which are by definition global, like climate change and how you can take that into account. Do you think that some jurisdictions are ahead of others in terms of looking at, if you like, new issues like innovation, competition, or even climate change to the extent that can be applied in a merger analysis? Do you think that you can just differentiate, and do you think that this increased collaboration will maybe level the playing field, if you like, bring up regulators to meet each other so far as they can within their own rules?
Yeah, you raise a really interesting point, Matthew, and I've had this discussion with a number of other practitioners over the last several months as to whether the United States was falling behind or was somehow lacking in enforcement innovation, or thinking deeply about these kinds of issues and how to look at transactions, and whether jurisdictions or regions like whether the European Commission or the CMA or other regulators were really ahead of the times in thinking about climate change and thinking about innovation and thinking about different types of harms. And on top of it, whether certain jurisdictions were also already looking at the public interest standard and looking at whether or not you should be thinking about a broader set of concerns beyond the consumer welfare standard and whether or not prices go up. So I think, yes, the answer is that there is a real benefit potentially of global collaboration, in the sense that, maybe all of the regulators will be thinking about issues similarly, or they'll start looking to one another, and particularly the U.S., to the extent that some have said they have not been on the forefront of these types of analyses. I think the issue remains that in the U.S. we just have a different system than some of the jurisdictions that have been able to be a little bit more cutting edge on their theories of harm. And I think that's what some of the legislative change that's currently being proposed in the U.S., is at least part of trying to solve for those issues. So in the U.S., of course, there are very little. There's very little language in any of the antitrust laws, and so much of the enforcement and interpretation comes from courts. And to the extent that some regulators have said that the courts have let too many deals have gotten through because parties think that they can sort of go to court and get their deals through because of the standards.
What do you think about collaboration on? We've been talking a lot about merger control, Meghan. What do you think about collaboration on the antitrust side? Like we referred to big tech earlier, and there are other issues. Do you see this coordination and collaboration equally applying there? I guess there are fewer timing issues generally with these cases because they're less often timing requirements, but presumably this push isn't only on the merger control side. We should be worried as practitioners and companies about more discussion in their smoke-filled room on the general antitrust or competition side.
Yeah, I completely agree with that statement, that we would see, or we're expecting to see, increased cooperation on the conduct side as well, particularly as regulators are starting to think of, as you said, the substantive assessment similarly, or are sharing information and sharing views on certain types of conduct. So yeah, I would absolutely agree, the same kind of collaboration and coordination to take place the conduct side. And of course, we're seeing parallel investigations of the tech companies in the US, in the EU, in a number of jurisdictions all simultaneously. And each of them seems to be taking a slightly different approach or, looking at different issues at different times. But yeah, I would absolutely agree. We should expect more collaboration on those as well.
We've been talking about the legal side. How do you think this plays in with the what you might call public affairs or government relations or lobbying? As you and the listeners know, these cases are often the subject of wide-ranging lobbying in Brussels and, of course, in Washington. Is that expanding to? I mean, I think Brussels and Washington probably have more lobbyists and government relations people than the rest of the world, combined. Probably only in antitrust. Do you see that expanding to other big jurisdictions? And if so, where is it? Is it really happening?
Oh, well, I think you're absolutely right in saying that public relations and public affairs has a role to play in merger review. And as antitrust has become increasingly politicized, I think that's become even more so. And being mindful of really the greater political landscape in which a deal takes place is important. And it's especially important in the context of increased coordination among regulators. So, for instance, messaging surrounding a deal really needs to be carefully balanced to be perceived favorably across jurisdictions. For instance, statements to regulators about creating a so-called national champion to combat new entrants from places like China or other countries may be helpful to the deal rationale when speaking with the US and EU regulators, but less helpful if such statements are shared with Chinese regulators or they hear those statements, and it really could trigger a backlash in China. So that doesn't directly answer your question, which was really about, do we see an expansion of a public affairs strategy in other jurisdictions? But I think it's global. I mean, I think the importance and the role of having messaging surrounding your deal that is very carefully thought through, such that it doesn't tripwires in any jurisdiction, is critical, irrespective of jurisdiction.
Well, I think what you highlight, Meghan, is public affairs has always been a part of deal discussions, things that the communications teams are thinking about. And I think what we've seen maybe in the past 5 years is increasing desire to have antitrust counsel review that and vet it and add to it in a way that may not have happened 10 years ago, because we recognize it's an important component to the overall review and how it may be perceived by consumers and by the regulators. So, well, Meghan, this has been an incredibly interesting conversation, and we'll see what will happen in the next 4 or so years. But before we let you go, we like to ask all of our guests a few questions. The first is to tell us something about yourself that we wouldn't know about you if we only knew you professionally.
That is a really good question. And as many people who know me professionally, you'll know that I am pretty much an open book professionally and also personally. But most people don't know this about me, and this is really random. But the first concert I attended, which was when I was in high school, was Prince, and I loved Prince in the late 90s. So I listened to the hits and the B-sides, which is a box set, over and over and over for a couple of years on repeat. So when I went to this concert, my friend and I were some of the youngest people at the concert by decades, and I managed to impress the fellow concert goers with my ability to sing along to just about every song on his set list.
That's great. And not surprised if no one knew that about you. And Meghan, what would you, any advice, I guess, you have for our younger listeners who are looking to do what you do?
So it's almost cliche to say it, but I'll say it anyway. say yes to all opportunities, even those opportunities that don't really feel like opportunities. When I was a junior associate, I said yes to everything. I took on unglamorous projects. I offered to help others when I had already too much on my plate. I did lots of things that were terrifying. And each time I took on another thing, another opportunity, I really gained something or learned something or earned somebody's loyalty. And on top of that, I gained a real broad set of experiences early on, which meant that as I became more senior, I could take on more challenging work. So I think of it as taking the 101 classes in my first and second year of working at a law firm as an associate, so that I could be ready for the 400 and 500 level classes in my fourth and fifth year. And I think I really was ready for those more senior opportunities because I had taken on so much as a junior just because I wanted to learn. So I would advise all young attorneys to view all of the extra work that lawyers do as an opportunity to learn and to grow.
Great. Wonderful advice. So now our final segment, what we call the Curious Hat.
Oh, it's time for the Curious Hat!
So Meghan, I'm going to ask you to pick a number 1 through 25.
Number 3.
Number 3. Okay. Maybe now a little bit more relevant. What is your favorite vacation destination?
Gosh, my favorite vacation destination is probably a European city. So it's a toss-up between Rome or Paris. And they are obvious choices, but I really love being in cities and I love being able to just explore. And I feel like those cities in particular are so just packed with history and packed with interesting things to see, to eat, to smell. So I would love to go back to Rome and or Paris in the near term.
Do you have any favorite spots in either city? A favorite tourist location or restaurant or cafe?
Gosh, well, in Paris, one of my favorite things to do was to sit on the steps of Sacré-Cœur and look out over the city. And so when I was in college, I did a summer internship in Paris, and I would spend many hours just sitting on the steps, watching the people and watching the city. That's one of my favorite things to do when I'm in Paris.
City watching, yep. Certainly in New York City and even DC, it's sometimes fun to do that as well. So
absolutely.
Well, Meghan, again, thank you for your time today. And to our listeners, thanks for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.